In 1898, a record that should exist simply doesn't. No erasure marks, no missing page, no correction filed. At the New York County Clerk's office, an absence appears where continuity is expected, and that absence carries legal weight, reputational risk, and permanent loss. This video examines how the New York County Clerk's office in 1898 became the center of a case defined not by what was changed, but by what was never done, and why a single missing entry suggests a decision made in silence. The mini-verdict is direct. Nothing was altered because nothing needed to be. The outcome was achieved through deliberate omission. The evidence begins with a concrete fact, a continuous index sequence that breaks where it should not, during a year when records were expected to be meticulous, not flexible. By the end of the 19th century, New York had entered a moment of formal consolidation. In 1898, the creation of Greater New York joined boroughs, expanded administrative reach, and placed unprecedented pressure on clerks, courts, and registries to standardize how the city documented itself. Public confidence depended on continuity. Property titles, inheritances, reputations, and commercial standing were not abstractions. They were anchored to ledgers, indices, and certifications. In this environment, the absence of a record was not a minor inconvenience. It was a legal condition. The Gilded Age is often remembered through its visible symbols: mansions along Fifth Avenue, institutional façades in Beaux-Arts stone, and the public philanthropy of old money families. But beneath that surface ran a quieter infrastructure of authority. The city's power did not rest only in courts issuing orders or officials signing directives. It rested in the routines of registration, when an entry was made, when it was deferred, and when it was quietly allowed to lapse. The press of the period understood this tension well. Newspapers reported on fortunes and scandals, yet relied on official records to legitimize outcomes. What could not be proven could not be printed as fact. In the case that opens this investigation, a legal researcher, working not from rumor but from books, meant to be exhaustive, identified a gap in a sequence designed to leave no gaps. The action was simple and verifiable, a comparison of index volumes before and after 1898. The consequence was immediate and unsettling. If the omission were accidental, it would be corrected. If it were clerical, it would be annotated. Instead, the absence persisted, unremarked and unchallenged, while time continued to do its work. This matters because silence in administrative systems is not neutral. During the Gilded Age, delay could resolve disputes more effectively than judgment. Without a recorded decision, claims weakened. Without an entry, rights became harder to assert. For those without institutional leverage, waiting was not a strategy. It was a loss. Estates settled without contest. Reputations stabilized. The public image of order remained intact, while private consequences accumulated out of view. The risk of the era was not chaos. It was the appearance of stability masking unequal outcomes. As the city expanded and its records multiplied, discretion moved from the visible to the procedural. No document needed to be altered if a necessary step was simply never taken. No order needed to be given if silence allowed the matter to resolve itself. That is the environment in which this case belongs. A moment when omission could function as policy without ever being named as such. If a ledger line can disappear without a trace, who decides when an archive speaks and when it stays quiet? Subscribe so you don't miss the next file, and if this intrigues you, leave a like. We begin with a room built for permanence, bound volumes on a long table, dated spines aligned, and a single place where the sequence breaks. An empty space that should not exist, waiting to be noticed. 2. understand why an absence in an index book could function like a verdict in 1898, you have to step back into how New York actually governed itself during the Gilded Age. Not in speeches, not in public ceremonies, but in the quiet routines that decided what would be addressed, what would be delayed, and what would be allowed to exhaust itself into silence. The decade did not feel stable on the ground. It was crowded, fast, legally dense, and politically transactional. Wealth rose in visible structures, brownstones, new hotels, club facades, and the long, polished corridor of Fifth Avenue respectability. But the city's real stability depended on administration holding together under pressure. And in that system, delay was not merely a byproduct, it was an instrument. The period between 1873 and 1900 is often summarized as a contest between industrial fortunes and urban reform. But for the clerks who kept the city legible on paper, it was a contest between volume and capacity. The Panic of 1873 and later the Panic of 1893 were not just financial episodes. They were shocks that widened disputes over property, debt, and inheritance, the kinds of disputes that did not vanish when markets recovered. Every downturn produced more contested estates, more liens, more refilings, more petitions. By the 1890s, the machinery of record-keeping had become a bottleneck that could shape outcomes simply by deciding what moved and what did not. That is the risk environment your opening absence belongs to, not a conspiracy culture, a capacity culture, a system where the difference between action and non-action could settle a dispute without a signature. Tammany Hall is central to this context because it was not a rumor and it was not a symbol. It was a working political organization that influenced appointments, promotions, and the informal incentives inside municipal offices. By the late 19th century, the city's administrative life ran through patronage as much as merit, and patronage systems have a distinct logic. They reward continuity, minimize public friction, and manage conflict in ways that preserve the structure itself. In practice, this often meant that difficult matters were not always denied in a way that created a clear target for appeal. They were deferred, they were routed, they were held, they were placed into a category where no one could later point to a single moment of refusal. That is not melodrama. It is an administrative style. And it mattered. Because the people who could afford time, who could afford lawyers, private negotiations, and social insulation, were not harmed by prolonged ambiguity in the same way as people who needed a clean answer to protect a claim. The Gilded Age elite understood something that ordinary claimants learned too late. A clean paper trail is not just proof, it is leverage. Newspapers like the New York Times and the New York World thrived on the public theater of wealth, scandal, and civic improvement, but even aggressive reporting depended on what could be stated as record. Reputation was a currency that moved through print, but it was stabilized through documentation. If a dispute over an estate, a title, or a transfer remained unresolved in the formal sense, the press could frame it as a pending matter, a complication, an unfortunate ambiguity. That language protects the powerful. A public accusation is risky. A public uncertainty is manageable. In a city where old money institutions prized permanence, uncertainty was often preferable to a decisive ruling that could embarrass a family, a trust, a club, or a courthouse. The public image remained intact while private outcomes were arranged elsewhere. This is why the phrase "silence institutional" is not philosophical here. It is procedural. Consider what it means for an office to have overlapping competencies. A claimant files with one desk and is told the matter belongs to another. A clerk notes that a related entry should be elsewhere. A court clerk waits for a confirmation that never arrives. The file drifts across jurisdictional seams until it becomes stale. The action is concrete. Paperwork is redirected and held pending, not resolved. The consequence is concrete. Deadlines expire, memories fade, witnesses disappear, and the claimant's ability to prove continuity weakens. In private life, time can heal. In record systems, time can erase. The creation of Greater New York in 1898, a real and verifiable reorganization, intensified every one of these dynamics. Consolidation expanded the city's administrative territory and multiplied the number of records that had to be integrated, cross-referenced, and standardized. Offices were under pressure to appear orderly while absorbing new burdens. In that moment, a missing entry is not simply one missing thing. It is a fault line in the very claim the city made about itself, that the records were comprehensive and reliable. The more the city insisted on order, the more dangerous a visible inconsistency became. That is why silence had value, not because someone feared the truth in a dramatic sense, but because the institution feared the implications of admitting it could not keep itself consistent. In this environment, deliberate omission becomes plausible not as a cinematic plot, but as a rational outcome of incentives. If a situation threatened a stable public narrative about a family's holdings, a trust's legitimacy, a transfer's cleanliness, or an inheritance's finality, there were multiple ways to address it, and not all of them required falsification. Falsification leaves traces. It creates a clear criminal act. It produces someone's handwriting in the wrong place. Omission is cleaner. Omission can be framed as backlog, misrouting, incomplete documentation, or insufficient information. The action is simply that an expected step is not taken. The consequence is that the system's default settings do the rest. Claims weaken, negotiations shift, and the status quo hardens into permanence. The public-facing architecture of the era, courthouses, registry rooms, archive stacks, contributed to the illusion that documentation was neutral. Beaux-Arts stone and civic symmetry suggested stability, fairness, permanence. But inside those buildings, the key decisions were not always the ones carved into marble. They were the ones embedded in workflow. Who decides which ledger is authoritative? Who decides which index is working versus reference? Who decides whether an anomaly is corrected publicly or handled quietly? Those decisions could be framed as technical, but their consequences were social and financial. A family's name could pass intact through society because the paper story stayed clean. A weaker claimant could be made to look speculative because the paper story remained incomplete. The Gilded Age also operated on a strict hierarchy of credibility. A well-known name, an established firm, or a recognized institution could initiate a problem without appearing desperate. A lesser name had to push harder, file more often, insist more plainly, and insistence in elite systems is frequently treated as a breach of decorum. That matters because decorum becomes an administrative filter. A polite inquiry can be delayed without offense. A forceful demand can be labeled troublesome. The action is subtle. Requests are answered with vague deferrals. Under review, awaiting confirmation, referred to another office. The consequence is a disparity in endurance. The institution can wait longer than the individual can. By the time your story arrives at the New York County Clerk's office in 1898, the city already had a mature practice of managing conflict without producing a single decisive page that could be held up in court or quoted cleanly in the press. Tammany Hall's broader influence reinforced this style because it rewarded offices that kept disputes from becoming public, kept allies from being embarrassed, and kept administrative continuity from being questioned. That does not require a direct order in every case. It requires a culture where non-intervention is often safer than intervention, where inaction can be justified as caution, where absence can be reframed as clerical limitation rather than institutional choice. And this is the specific danger when a record system is treated as the backbone of property, inheritance, and reputation. The line between not found and not entered becomes a line between having rights and losing them. The costs are not abstract. They can be legal when a claim fails for lack of documentary continuity. They can be financial when an estate settles without a contested party. They can be social when reputations remain unblemished because no formal dispute ever becomes visible. The city's public story stays clean. The private consequences remain buried inside routine. So when the researcher in your opening pages finds that an expected entry isn't there, the discovery lands inside a system that has long understood how silence can do work. The absence is not yet an accusation. It is a condition. But it is a condition that only exists because at some point, someone with authority chose the safest option: delay, deferral, non-intervention, and the quiet comfort of letting time resolve what the institution preferred not to touch. That brings us to the next step, because omission does not happen by itself in a functioning office. In 1898, a request still had to reach a desk, receive a date stamp, and be seen by someone who could choose whether it would move forward. The context explains why silence was useful. The next question is simpler and more concrete. Who had the power to act when the file first landed, and what did they do with it, besides letting it sit? The surviving trace looks like an ordinary object at first glance. A thin petition jacket stamped "Received" resting in an intake tray, with no ruling attached. In 1896, the question was no longer whether the system allowed silence to do work, but who, precisely, had the authority to interrupt it, and chose not to. The surviving trail does not point to a dramatic confrontation or a denied motion, but to a moment of administrative contact that ended without escalation. A formal petition was delivered to the Registry of Deeds, the institution responsible for maintaining the continuity of property-related records and their associated indices. The action is documented in intake markings that confirm receipt, date stamped, ledger referenced, file jacket opened. What follows is not a refusal in writing, but something more consequential for those who depended on the record's movement. The petition was archived without a substantive response. At the time, the Registry of Deeds was not a passive warehouse. It was an active gatekeeper in a legal environment where registration determined enforceability. The office did not merely store documents. It validated them through sequencing, cross-referencing, and certification. In 1896, when a party submitted a request for registral clarification, whether to confirm an entry, correct a discrepancy, or acknowledge an omission, the office had clear procedural options. It could issue a notice of deficiency. It could request supplementary material. It could escalate the matter to judicial review. It could annotate the index pending resolution. Each of these actions left a trace and imposed a timeline. None of them occurred here. The decision under scrutiny is therefore not the absence of power, but the presence of capacity without its exercise. The Registry of Deeds had the authority to intervene in the narrow technical sense that defined legitimacy in the Gilded Age. Its clerks and supervisors were empowered to determine whether a record was complete, whether an index sequence was intact, and whether a deviation required correction. When the petition arrived in 1896, it entered a system designed to transform questions into administrative movement. Instead, it encountered a stopping point that was procedural rather than declarative. The actors involved were not anonymous. Intake clerks recorded submissions. Supervising registrars reviewed classifications. Legal counsel attached to the office advised on jurisdictional boundaries. The decision not to advance the petition required at least tacit agreement across these roles. This is where the language of administration becomes important. Files are not simply ignored in functioning offices. They are categorized, they are routed, they are held pending further review. The action taken here was specific. The file was placed into archival status without triggering the next procedural step. In effect, the system acknowledged the petition's existence while denying it procedural life. The consequence of this choice was immediate and material. Without a response, the petitioner lacked a formal determination to challenge. There was no denial to appeal, no correction to contest, no annotation to cite. The legal posture of the matter remained undefined, which in practical terms meant it favored the existing state of affairs. In the Gilded Age, undefined status often functioned as resolution. Time operated in favor of established positions, particularly those tied to property, trust administration, and reputation. The longer a discrepancy remained unaddressed, the harder it became to frame it as urgent rather than speculative. This decision to archive without response also insulated the institution itself. By avoiding a written position, the Registry of Deeds reduced its exposure to scrutiny. A denial could be examined, a correction could be traced. Silence, framed as administrative backlog or jurisdictional ambiguity, left little for external actors to interrogate. Newspapers relied on formal actions to anchor reporting. Courts relied on explicit determinations to assert review. In the absence of either, the matter remained invisible beyond the parties directly affected. What makes this moment distinctive is not that a petition failed, but that it failed quietly in a system that otherwise documented its own operations with precision. The Gilded Age produced vast paper trails precisely because wealth, inheritance, and urban growth demanded it. Deviations from that norm are therefore significant. In 1896, the Registry of Deeds was under pressure to maintain continuity as New York approached consolidation. The cost of acknowledging a flaw in the record system at that moment was not merely technical. It threatened confidence in the machinery that underwrote property rights and social stability. The decision not to act also reflects the hierarchy of credibility embedded in the era's institutions. Petitions did not carry equal weight. The perceived standing of the requesting party, its connections, resources, and ability to endure delay shaped how offices responded. Capacity without exercise is not neutral. It distributes risk unevenly. Those with patience and capital could negotiate informally or wait for circumstances to settle. Those without were forced to accept administrative inertia as outcome. Importantly, this was not a rogue clerk's choice. The file's status indicates institutional handling. Archival placement required acknowledgement at supervisory levels. The absence of a response was therefore a collective administrative posture, not an oversight. It demonstrates how decision-making in elite systems can occur through omission, producing effects indistinguishable from affirmative rulings without incurring the same visibility or accountability. The long-term consequence of the 1896 decision was to set conditions under which later alterations could occur without confrontation. Once the petition was archived, the record system continued to function around it. Indices were updated, volumes were reclassified, new entries were added. The unresolved matter did not disappear, it was rendered inert. That inertia protected existing holdings and avoided the creation of a precedent that might invite similar challenges. From the perspective of governance, this is the critical insight. Silence can be a choice precisely because the system is capable of speaking. The Registry of Deeds did not lack tools. It declined to deploy them. In doing so, it preserved institutional calm at the expense of procedural clarity. The cost was borne by those whose claims depended on the system's willingness to act. As the file settled into archival quiet, its physical presence remained deceptively ordinary. A jacket stamped "Received," a date from 1896, a ledger reference penciled in the margin, no ruling attached, no correspondence filed. The paper survived, but the decision it required was withheld. That is the moment this investigation isolates as the pivot from potential correction to managed silence. The next phase does not involve new actors entering the scene, but changes occurring around the file itself. When a system continues to operate, unresolved elements are not static. They are reclassified, moved, or reframed to fit evolving workflows. The question that follows is not who had the power to act, they did, but what changed in the material world of records after the decision to let the file sit. The answer begins not with a courtroom, but with a shelf. In 1897, the point of pressure shifted from clerical discretion to judicial restraint, and that shift matters because courts were the last place where silence could still be converted into a record. The New York Supreme Court had the authority to clarify uncertainty, to compel correction, or to define jurisdiction when lower offices stalled. That authority was not theoretical, it was exercised daily in property disputes, probate challenges, and registral conflicts that threatened to spill into public view. In this case, the court was presented with a narrow procedural opportunity: issue an order directing clarification of an unresolved registral question. The action taken was specific and traceable. The court declined to issue such an order. The consequence was equally specific. The absence of a directive created a permanent legal gray zone that no subordinate office could resolve on its own. The choice not to act did not occur in a vacuum. By 1897, the New York Supreme Court was operating in an environment shaped by consolidation, political sensitivity, and a rising volume of technically complex cases. Judges were acutely aware that their rulings did more than resolve individual disputes. They established expectations about how institutions behaved. An order compelling registral clarification would have done more than address a single file. It would have signaled that omissions could be challenged and corrected through judicial pressure. That signal carried risk. It invited scrutiny of record-keeping practices at a moment when the city was trying to present administrative coherence, not expose seams. The procedural posture of the matter made judicial silence easier to justify. There was no dramatic allegation before the court, no claim of forged documents or overt misconduct. What existed was an unresolved absence and a request for clarification. In administrative language, that distinction matters. Courts are built to respond to conflicts framed as disputes, not to gaps framed as technical. Irregularities. By declining to intervene, the court could characterize its inaction as restraint rather than abdication. The action was omission. The explanation, implicit rather than written, was that the matter did not rise to the level requiring judicial direction. This is where non-decision becomes policy. Neutrality, in a legal sense, is often described as refraining from interference. But in systems dependent on momentum, refraining has direction. The New York Supreme Court did not return the matter for further development. It did not request additional briefing. It did not remand with instructions. The file was effectively left where it stood, unresolved but acknowledged. That posture froze the situation in a way that favored existing conditions. Without an order, registries lacked cover to act. Without a ruling, claimants lacked a foothold to push. Silence cascaded downward through the system. acquiring force as it moved. The consequences of this judicial choice were not abstract. In property law, unresolved status tends to harden rather than soften. Time does not clarify gaps, it entrenches them. By refusing to issue a corrective or clarifying order in 1897, the court ensured that the ambiguity would outlive the individuals who first raised it. Estates settle, transactions close, reputations stabilize. Once those processes complete, reopening the underlying uncertainty becomes exponentially more difficult. The legal gray zone created by inaction did not merely persist, it matured. This distinction between neutrality and omission is measurable. Neutrality leaves the field open for future action. Omission closes it quietly. In this case, the court's silence did not preserve options, it foreclosed them. No subsequent office could claim authority to resolve what the court had declined to touch. The absence of an order became a boundary line. Clerks could point upward and say the matter had not been directed. Litigants could look upward and find no door. Left ajar, the system appeared calm, but that calm was produced by withdrawal, not resolution. The court's institutional incentives help explain why this path was chosen. A ruling compelling registral correction would have invited questions about how many similar gaps existed and whether they, too, required attention. It would have risked exposing a pattern at a moment when confidence in municipal administration was politically valuable. The press followed courts closely, and a visible judicial intervention could have reframed a technical irregularity as a systemic issue. Silence avoided headlines, silence avoided precedent, silence preserved the image of continuity. Importantly, this was not a passive failure to notice. The matter reached a point where action was possible and identifiable. The decision not to issue an order was itself a form of governance. Administrative law recognizes that discretion includes the discretion not to decide. In elite systems, that discretion is often exercised to protect stability rather than to maximize clarity. The New York Supreme Court's choice in 1897 fits that pattern. It maintained institutional equilibrium by refusing to disturb the surface, even as unresolved consequences accumulated beneath it. For those affected, the cost of this choice was structural. Without judicial direction, they faced a closed loop. Registries deferred to the absence of a court order. Courts pointed to the lack of a formal dispute. Each institution's restraint reinforced the others. This is how silence acquires durability. It is shared. No single actor carries the burden of decision, and no single document records it. The outcome exists without authorship. The broader implication is that legal systems do not require active collusion to produce unequal results. They require alignment of incentives. In 1897, the incentive to avoid disruption outweighed the incentive to clarify uncertainty. That calculus favored those whose positions benefited from inertia. Property tied to established names remained undisturbed. Claims dependent on timely correction weakened. The court did not grant anything to anyone, but its omission redistributed risk along familiar lines. From the outside, the system appeared to function normally. Cases were heard, orders were issued, ledgers filled. The absence of a single directive did not register as an event. Yet within the narrow corridor of this case, the refusal to speak was decisive. It converted a correctable omission into a fixed condition. The legal gray zone hardened into a boundary that subsequent actors would treat as natural. This moment also clarifies why omission is harder to challenge than action. Actions generate reasons, and reasons can be interrogated. Omissions generate silence, and silence offers no leverage. In 1897, the court's non-decision created a record of absence rather than a record of judgment. That absence traveled forward in time. shaping outcomes without ever appearing as a cause. By the end of that year, the matter no longer sat at the threshold of resolution. It had been returned quietly to the administrative environment that had produced it. The court's role was complete, not because it resolved the issue, but because it declined to define it. That refusal marked the transition from potential correction to managed ambiguity. What followed was not stasis, but movement elsewhere. When courts remain silent, institutions adapt around the silence. Files are reclassified. Indices are reorganized. Shelves change. The next phase of this investigation tracks what happened after the court stepped back, not in law books or opinions, but in the physical world of records. The trace that remains is not a ruling, but a stamped docket sheet bearing the date 1897, unsigned in the space where an order should be, resting in a folder that would soon be moved to a different shelf. By 1899, the center of gravity had moved away from courts and petitions and into a space designed to appear neutral, the archive itself. This is the point where omission became operational, and where the consequences of earlier silence were translated into a physical reordering of knowledge. The change did not arrive with a statute, a public notice, or a revised regulation. It arrived through routine archival procedure inside the Hall of Records, the building tasked with giving permanence to the city's memory. The action was concrete and verifiable. Books and indices were internally reclassified. The consequence was equally concrete. Access to information became conditional on institutional familiarity rather than public continuity. The Hall of Records was not a marginal office. At the turn of the century, it was the symbolic and practical heart of New York's documentary authority. Deeds, judgments, probate files, and indices converged there, arranged to suggest order and completeness. For the public, the building represented stability. For the legal profession, it represented finality. By 1899, as consolidation pressures intensified and older record systems were absorbed into a unified structure, the archive underwent what was officially described as organizational refinement. In practice, that refinement altered how continuity could be traced. The alteration did not involve destroying documents or erasing entries. That would have been visible and risky. Instead, it involved reclassifying how records related to one another. Index volumes that had once been directly cross-referenced were reassigned to internal series. Certain books were designated as reference only, while others became the primary access point for public searches. This distinction mattered. A reference book could confirm something for a clerk who knew where to look, but it no longer guaranteed discoverability for an outside researcher following a standard sequence. The action was procedural, reclassification. The consequence was structural. Continuity became conditional. What makes this shift significant is that it required no legal authorization. Archives possess discretionary power over arrangement, not content. By changing the way materials were grouped and consulted, the Hall of Records could alter outcomes without altering law. In 1899, that discretion was exercised quietly. No notice was issued to the bar. No announcement was made to the press. Researchers arriving at the counter were presented with a system that appeared intact, but which now relied on internal logic rather than visible sequence. This is where alteration diverges from decision. Decisions announce themselves. Alterations embed themselves. The earlier non-decisions created a space where ambiguity could survive. The archival shift gave that ambiguity a stable home. Once indices were reorganized, the absence identified in earlier years became harder to isolate. It did not vanish. It was displaced. A search that once led naturally to a missing entry now led to a procedural explanation. The material belonged to another series, another desk, another internal pathway. The institutional reasoning for such changes was defensible on its face. The volume of records had grown. Efficiency demanded new classifications. Consolidation required harmonization. These were real pressures. But their application was not neutral in effect. Reclassification privileges those who understand the system's internal map. Lawyers with long-standing relationships, clerks with institutional memory, and firms accustomed to navigating complexity could still locate what they needed. Others encountered dead ends, framed as procedural limits rather than substantive barriers. The consequence of this alteration was selective transparency. The archive did not close its doors, it reshaped its corridors. Information remained present but unevenly accessible. In practical terms, that meant that unresolved matters from the 1890s could persist without appearing unresolved. A missing link in a public sequence could be absorbed into a private classification. The archive continued to function, but the burden of discovery shifted from the institution to the individual. This shift had immediate effects on property and inheritance matters tied to older records. Claims dependent on demonstrating uninterrupted sequence now faced a higher threshold. Without knowing which internal series to request, a researcher could not easily establish that something was absent rather than merely relocated. The distinction matters because absence implies omission, while relocation implies misdirection. The former invites scrutiny. The latter invites deference to expertise. The press, for its part, rarely scrutinized archival rearrangements. Newspapers covered scandals, not shelving practices. As long as no document was publicly altered or destroyed, there was little to report. Reputation remained protected, not by secrecy, but by complexity. The cost of reputation loss in the Gilded Age was high, and institutions learned to manage that cost by ensuring that potentially destabilizing ambiguities did not surface as clear narratives. What changed in 1899, then, was not the content of the record, but the conditions under which the record could speak. The archive became an active participant in governance. By reclassifying materials, it influenced which questions could be asked and which answers could be reached. This is alteration in its most effective form: operational, quiet, and durable. The long-term consequence was to solidify the outcome produced by earlier silence. Once the archive's internal logic shifted, revisiting unresolved matters required more than persistence. It required insider knowledge. That requirement filtered claimants along familiar lines of class and connection. Those tied to established institutions navigated the system with relative ease. Those outside it encountered procedural walls framed as neutrality. This alteration also insulated the Hall of Records itself. By embedding ambiguity within structure, the archive avoided responsibility for any single outcome. Clerks could point to classification rules. Supervisors could point to consolidation mandates. The absence of a record was no longer an anomaly, it was a byproduct of organization. The institution's authority remained intact because its actions were framed as technical necessity rather than choice. By the turn of the century, the physical world of records had adjusted to accommodate the silence established earlier. Files still existed, ledgers still aligned neatly on shelves, but the pathways between them had changed. What once could be traced through visible sequence now required guidance. The archive had not erased history. It had learned how to contain it. The trace that survives from this moment is unremarkable unless you know what to look for. A catalogue notation added in 1899, redirecting a series to an internal reference shelf, initialed by a clerk whose name appears nowhere else in the file. The ink is intact, The paper is clean, the effect is lasting. This alteration resolves one tension while preparing the next. With the archive reorganized, the system no longer needed to actively suppress anything. It only needed to operate as redesigned. The question that follows is not what was changed, but who benefited from a world in which access depended on position rather than proof. The answer lies not in the stacks, but in the assets that remained, undisturbed while others quietly slipped out of reach. In 1901, the effects of earlier silence stopped being procedural and became personal. The matter reached the surrogate's court, the forum responsible for determining inheritance, standing, and the final disposition of estates. What arrived there was not a fresh dispute, but a claim already weakened by years of administrative inertia. The court's action was clear and recorded. A property claim was denied on the grounds of insufficient proof. The consequence was irreversible. The claimant lost all succession rights tied to that estate, not because a competing document prevailed, but because the necessary continuity could no longer be demonstrated. This is the first point in the record where loss becomes visible. Until then, the case existed in a space of ambiguity, managed through delay, non-decision, and reclassification. In surrogate's court, ambiguity does not linger indefinitely. Probate demands closure. Estates must be settled. Assets must be distributed. By 1901, the court was not asked to investigate why a record was missing or how an omission had occurred. It was asked to rule on whether a claimant could meet the evidentiary threshold required to disturb an existing settlement. The absence of proof was treated as a factual condition, not as a problem to be solved. The action that mattered was not dramatic. There was no accusation of fraud, no finding of misconduct. The court simply declined to recognize the claim. The language was administrative and restrained. Insufficient proof is not a judgment on intent. It is a judgment on capacity. It signals that whatever may have once existed could not now be established in a form the court was obligated to accept. In probate, that distinction is decisive. Rights that cannot be proven do not linger in suspension. They expire. The consequence extended beyond the immediate claimant. Inheritance law operates on finality. Once an estate is settled and distributed, reopening it becomes extraordinarily difficult. The 1901 denial did more than resolve a single petition. It closed a chapter. Assets were confirmed in the hands of those already recognized. Titles hardened. Financial arrangements stabilized. The claimant's connection to the estate was not merely weakened, it was erased from legal consideration. This is where disappearance occurs, not in the destruction of a document, but in the disappearance of standing. A name that once could have appeared in an inventory no longer did. A potential heir ceased to exist in the official narrative of the estate. The loss was total and procedural. There was no appeal grounded in new evidence because the system had already ensured that such evidence could not be produced. The silence that preceded the hearing became the decisive factor at it. The court's role was narrowly defined, and that narrowness matters. Surrogate's court did not revisit the conduct of registries or archives. It did not question why proof was lacking. Its mandate was to assess what was before it in 1901, not to reconstruct what might have been available years earlier. This constraint is often misunderstood as indifference, but it is structural. Probate courts enforce the consequences of time. They do not reverse it. For individuals without political or social capital, this moment represented the end of the line. Informal negotiations, if they existed, carried no weight here. Social pressure could not substitute for documentation. The claimant faced the court alone, with a record that no longer spoke. The institutional silence that had protected stability elsewhere now manifested as a personal loss that could not be undone. The damage was not limited to financial deprivation, though that was significant. Inheritance in the Gilded Age was bound to reputation. To be recognized as an heir was to be acknowledged as part of a lineage. The denial severed that recognition. The claimant's relationship to the family history was rendered legally irrelevant. In public terms, nothing appeared to have gone wrong. The estate passed cleanly. The press had no scandal to report. In private terms, the erasure was complete. This outcome illustrates how omission converts into disappearance. No record needed to be destroyed for a right to vanish. The system required only that the proof of that right failed to arrive when demanded. By 1901, the earlier decisions to defer, to reclassify, to remain silent had matured into a condition the court treated as natural. The absence of evidence was no longer an anomaly. It was the basis of judgment. The broader consequence is measurable. Once succession rights are denied, related claims collapse with them. Financial arrangements tied to those rights dissolve. Potential challenges to property titles lose standing. The estate's distribution becomes the foundation for future transactions. What was lost in 1901 did not return in another form. It was absorbed into the settled order. This is why the phrase "immediate consequences" is accurate. The loss did not unfold slowly after the court's decision. It occurred at the moment of denial. The claimant did not lose a chance. They lost recognition. From that point forward, their connection to the estate existed only in memory, not in law. The system's design ensured that this outcome appeared ordinary. Surrogates' court decisions of this kind were routine. Files closed, ledgers updated, life moved on. Yet the ordinariness is precisely what made the damage durable. A dramatic injustice invites attention. A routine denial becomes invisible. The silence that had once been an administrative posture now had a human cost that could be measured in assets, status, and history. The court did not create that silence, but it enforced its consequences. In doing so, it transformed omission into disappearance, completing a process that had begun years earlier in offices and archives. What remains from 1901 is a thin probate file stamped with the court's decision and an inventory list where a name never appears. The paper is intact. The ruling is clear. The loss is final. With the claim extinguished, the system no longer needed to protect itself through silence. The matter had resolved itself. The investigation now moves away from those who lost and toward those for whom nothing changed. With the claim gone, assets remained undisturbed, titles unquestioned, and reputations intact. The next question is not what disappeared, but who stood on the other side of that disappearance, benefiting from a world in which silence had already done its work. By 1902, the effects of silence were no longer diffuse. They had settled into a pattern that could be observed, measured, and traced to specific beneficiaries. The most visible among them were the private entities managing concentrated wealth along Fifth Avenue, where estates were structured to endure volatility and absorb uncertainty without public friction. In that year, consolidation activity within Fifth Avenue trusts accelerated quietly. The action was concrete and documented. Assets were aggregated, titles confirmed, and holdings rolled into long-term trust vehicles without facing active judicial contest. The consequence was equally concrete. Wealth remained intact, and reputations passed forward unmarked by dispute. This was not the result of a single favorable ruling or a contested victory in court. It was the byproduct of a cleared field. With claims denied in probate the year before and registral ambiguities absorbed by archival structure, Trust administrators operated in an environment where uncertainty had already been neutralized. In practical terms, consolidation in 1902 meant that properties could be transferred internally, income streams stabilized, and governance provisions tightened without fear that a dormant claim would resurface to interrupt the process. Silence had done the work that litigation often does, but with none of the exposure. Trust structures of the period were designed to benefit from exactly this condition. They thrived when timelines were predictable and when the universe of recognized claimants was narrow. The absence of active challenges reduced risk premiums, simplified administration, and allowed trustees to present portfolios as clean, settled, and insulated. The action taken, formal consolidation, was routine. The advantage gained, immunity from retroactive disruption, was strategic. Nothing in the trust deeds needed to reference the earlier omissions. They simply reflected a world in which those omissions had already erased competing interests. The benefit was systemic rather than personal. Individual trustees did not need to intervene, lobby, or suppress. Their position improved because the surrounding institutions had chosen non-intervention earlier. This is what makes the benefit difficult to isolate, yet impossible to ignore. By 1902, the environment favored stability over correction. Assets already under management remained there. Properties already associated with prominent names stayed associated with them. The trusts functioned as amplifiers of institutional silence, translating administrative inaction into durable financial advantage. The preservation of reputation was as important as the preservation of capital. In the Gilded Age, public confidence in a family's holdings mattered not only for social standing, but for credit, partnership, and political access. A contested inheritance could tarnish a name even if the outcome ultimately favored the incumbent. Silence avoided that cost entirely. With no public dispute to narrate, the press had nothing to frame as controversy. Trust reports appeared orderly. Annual statements reflected continuity. The story told to the public remained one of stability, not survival. This benefit extended beyond the trusts themselves. Banks, insurers, and counterparties relied on the appearance of settled ownership. When pricing risk, a property managed by a Fifth Avenue trust in 1902 carried with it an assumption of clean title. That assumption lowered transaction friction and widened opportunity. The action, recognition of consolidated ownership, produced a chain reaction of confidence. The consequence was compounding advantage, not merely retained assets. What makes this moment analytically important is that the benefit was indirect. No record shows a trust requesting silence. No document records an agreement to let claims lapse. The trusts benefited because the system had already shaped outcomes in their favor. This is the defining feature of institutional advantage. It accrues without explicit request. Silence becomes protective because it aligns with the interests of those whose positions are already secure. The contrast with those who lost is stark, but procedural rather than moral. Where claimants required documentation to establish rights, trusts required only the absence of disturbance. Where claimants faced deadlines, trusts faced continuity. The same silence that functioned as a barrier for one group functioned as insulation for another. This asymmetry was not accidental. It was a product of how authority, time, and record-keeping intersected. By 1902, the consolidation of assets within Fifth Avenue trusts also had a secondary effect. It normalized the outcome of the earlier omissions. Once assets were embedded within complex trust structures, disentangling them would have required extraordinary intervention. The cost of revisiting old gaps increased dramatically. Any challenge would have risked destabilizing multiple holdings, not a single estate. The threshold for action rose, and with it, the likelihood that no action would be taken. This is where silence transforms from an event into a condition. The trusts did not merely benefit from a past omission, they operated in a landscape reshaped by it. Their administrative routines assumed that unresolved matters were resolved. Their reports treated absence as closure. Their governance frameworks encoded the outcome as baseline reality. The benefit also extended into the social realm. Families associated with these trusts continued to occupy prominent positions without interruption. Philanthropic activities proceeded. Club memberships remained unchallenged. In an era when reputation functioned as social currency, the lack of public dispute preserved value that could not be quantified on a balance sheet. The cost of reputation loss was avoided entirely, not through defense, but through invisibility. It is important to note what did not happen. There was no redistribution, no reallocation prompted by new findings, no corrective mechanism triggered by conscience or reform. The trusts did not gain more than what they already held. They gained certainty. In systems of wealth, certainty is often more valuable than expansion. It allows planning across generations. It allows institutions to present themselves as guardians of permanence rather than beneficiaries of chance. The legal consequence of this consolidation was to further entrench the status quo. Once trust structures absorbed the assets, the window for challenge narrowed to the point of closure. Statutes of limitation, doctrines of finality, and practical barriers combined to protect what had been consolidated. The system no longer needed to remain silent actively. Its earlier silence had matured into structural protection. This is the quietest form of benefit. It leaves no celebratory record. It produces no single document that can be cited as proof of favoritism. Yet its effects are visible in what does not change. Properties remain in the same hands. Names remain associated with the same addresses. Wealth passes forward without interruption. The investigation at this stage does not accuse the beneficiaries of orchestration. It identifies alignment. The silence that harmed some stabilized others. The institutions that declined to act created an environment in which trust consolidation could proceed without resistance. By 1902, the outcome was locked in not by force, but by completion. The physical trace of this benefit is deceptively mundane. A trust ledger updated to reflect consolidated holdings, dated that year, stamped and signed, listing properties without annotation or dispute. The pages are clean, the entries are orderly. The past appears settled. With beneficiaries identified, the inquiry turns toward a different kind of evidence. Stability often conceals cost, and cost leaves traces when examined closely. The next step is not to ask who gained, that has become clear, but to examine whether the record itself remains internally consistent once the dust has settled. The path forward leads to anomalies that do not fit the surface order, details that resist alignment, and values that do not quite match the story told in ink. By 1905, the case had reached a point where its survival depended less on active concealment and more on professional routine. This is when silence ceased to look like an exception and began to function as risk management. The institution that could have reframed the matter as misconduct was the New York City Bar Association, whose committees were charged with reviewing complaints, ethical breaches, and procedural irregularities within the legal profession. That year, despite the accumulation of unresolved effects, denied claims, archival, reclassification, and consolidated assets, no disciplinary representation was filed. The action was concrete in its absence. Nothing was submitted, nothing docketed, nothing opened. The consequence was institutional. The situation was absorbed into the background as non-exceptional. This matters because professional oversight bodies are often the last line between quiet irregularity and public scandal. In 1905, the Bar Association had both the standing and the mechanisms to initiate review without waiting for a courtroom crisis. It could convene committees, request explanations, and create records that, by their existence alone, signaled concern. None of that occurred. The lack of action did not signal ignorance. It signaled assessment. Silence was evaluated as the lower risk option. The legal profession of the early 20th century operated on a delicate balance between self-regulation and public trust. Too much exposure threatened the credibility of courts and registries. Alike, too little oversight risked erosion from within. In practice, the system leaned toward protecting its own coherence. Issues that could be framed as technical, isolated, or already resolved by time were rarely elevated. In 1905, the matter in question fit all three categories. There was no live dispute, there was no active litigant with standing, there was no document that could be pointed to as altered or forged. What remained was an accumulation of outcomes produced by omission. From an oversight perspective, that is the hardest kind of problem to prosecute. The absence of a disciplinary filing did not require consensus on innocence. It required consensus on risk. Opening an inquiry would have invited questions about earlier decisions, about registral practices, about archival discretion, and about judicial restraint. Each of those questions threatened to expose not a single failure, but a pattern. Patterns are dangerous because they create precedent. In 1905, the cost of precedent outweighed the benefit of clarity. Professional culture reinforced this calculus. Lawyers, clerks, and judges shared an understanding that not every irregularity warranted public examination. The language used to justify restraint was deliberately vague. Administrative discretion, lack of actionable complaint, no evidence of malfeasance. These phrases did not deny the existence of harm. They reframed it as outside the scope of professional discipline. The action taken was linguistic rather than procedural. The consequence was normalization. Normalization is not passive. It requires repetition. By declining to treat the matter as exceptional, the profession folded it into an existing category of tolerated outcomes. Files closed without comment. Committees moved on to clearer violations. Over time, the absence of review itself became evidence that nothing unusual had occurred. Silence produced its own alibi. The press followed the profession's lead. Without a disciplinary inquiry to anchor reporting, there was no narrative hook. Newspapers rely on events, charges filed, hearings convened, statements issued. In their absence, the story lacked shape. What remained was a settled estate, functioning trusts, and a record system that appeared orderly. The cost of reputation loss, which often triggers scandal, was never incurred. Silence prevented the very conditions under which outrage forms. This is how risk was managed in 1905, by avoiding the creation of records that could travel beyond institutional walls. A disciplinary file, once opened, acquires momentum. It demands resolution. It invites scrutiny from outsiders. By not opening such a file, the Bar Association contained the issue within professional memory rather than public archive. The action, non-filing, had a clear effect. It reduced exposure across multiple domains at once. The normalization also altered incentives going forward. When silence produces no penalty, it becomes a viable response to future ambiguity. Professionals learn from what triggers consequences and from what does not. By treating the case as routine, the system signaled that similar patterns could be absorbed without institutional damage. That signal mattered more than any single outcome. It shaped behavior. The consequence extended into doctrine. Without disciplinary findings, there was nothing to cite as cautionary example. Law schools, treatises, and professional guidance had no case to reference. The absence of a scandal became part of the educational environment. New practitioners encountered a system where omission had already been normalized, not as misconduct, but as administrative reality. This normalization did not erase harm, it redistributed it. Those who had already lost rights did not regain them. Those who had consolidated assets did not relinquish them. What changed was the interpretive frame. The situation ceased to be viewed as a problem and began to be viewed as a settled act. That shift is decisive because it transforms silence from a tactic into a condition. The Bar Association's restraint also insulated allied institutions. Courts could point to the lack of professional concern. Registries could point to the absence of disciplinary findings. Archives could point to standard practice. Each institution's silence reinforced the others. The system closed ranks without ever convening. The long-term effect was stability of appearance. By 1905, the case no longer threatened to disrupt public confidence. It had been domesticated by non-response. This is not accidental. Elite systems preserve legitimacy by narrowing the range of issues deemed worthy of attention. The cost of reputation is managed by ensuring that potentially destabilizing questions never achieve formal status. The action that defined this stage, the omission of disciplinary review, had a final consequence that is easy to overlook. It shifted the burden of proof entirely onto anyone who might later question the outcome. Without a professional record acknowledging concern, any future inquiry would appear speculative, retrospective, and disruptive. Silence hardened into authority. What remains from this moment is a paper trail defined by what it lacks. Annual reports without mention, committee minutes without agenda items, correspondence files without follow-up. The absence itself is the evidence of normalization. This stage resolves the tension between harm and visibility. The harm has already occurred. Visibility is now actively suppressed by routine. The system has learned how to live with the outcome. What it has not learned is how to reconcile that outcome with its own internal logic. The next step in the investigation does not ask why no scandal emerged. That answer is now clear. It asks something narrower and more dangerous. Whether the settled record, once normalized, remains internally consistent. Normalization often conceals strain, and strain leaves traces. The path forward leads to details that do not quite align, numbers that resist reconciliation, dates that drift, and signatures that appear where they should not. The place to look is not in the headlines, but in the margins. Between 1912 and 1924, the case entered its most durable phase, not through action, but through erosion. By this period, the matter no longer required active restraint, professional discretion, or procedural justification. It required only time. The responsibility for its custody had settled with the New York Municipal Archives, the institution charged with preserving official memory once files passed beyond operational use. The action taken during these years was simple and consistent. The records were maintained as they stood, left unreviewed, unreopened, and unreconciled. The consequence was decisive. The institutional version of events hardened into history, not because it had been confirmed, but because nothing remained to contradict it. This stage marks disappearance in its purest administrative form. No document was destroyed, no file was formally sealed, Instead, relevance itself disappeared. By 1912, the case no longer circulated through courts or registries. It lived only as a dormant set of papers, catalogued, boxed, and stored under classifications that reflected prior decisions rather than unresolved questions. The absence that once demanded explanation became a background condition. The longer it remained unchallenged, the less visible it became. The early 20th century provided ideal conditions for this kind of disappearance. The city's attention shifted toward reform movements, wartime mobilization, and later economic transformation. Administrative energy followed those priorities. Old disputes without active claimants were not revisited. The archive's mandate was preservation, not investigation. Its default posture favored continuity over correction. Maintaining the status quo required less justification than reopening. A closed chapter. The practical action taken by the archive was omission by maintenance. Files were retained without annotation. Index entries were left as they had been reclassified in earlier years. No cross-check was initiated to reconcile gaps that had already been absorbed into the system's structure. The records were neither altered nor corrected. They were simply allowed to persist in their existing form. The consequence was that the absence identified years earlier lost its identity as an anomaly. It became indistinguishable from the archive's ordinary noise. Time functioned as an ally of omission. With each passing year, the likelihood of correction diminished. Witnesses died, practitioners retired, institutional memory thinned. By the 1920s, few individuals remained who could recall the original context of the file, let alone articulate why it had once mattered. The archive did not erase the past. It outlasted those who could question it. This is where disappearance differs from loss. Loss suggests an event. Disappearance suggests a process. Over these 12 years, the case was not resolved, denied, or overturned. It was forgotten administratively. Its presence in the archive became purely custodial. It no longer generated action or concern. The system did not need to defend itself. Silence had already done its work. The disappearance also had legal consequences. By the time the period ended, statutes of limitation, doctrines of finality, and practical barriers made any reopening implausible. Even if a discrepancy were noticed, the cost of revisiting it would have far exceeded any institutional incentive to do so. The record's silence had matured into authority. What remained uncorrected came to be treated as correct. Socially, the effects were equally durable. The families and entities whose positions had been stabilized earlier continued without interruption. Properties remained associated with the same names. Trusts functioned without challenge. The absence of dispute became part of the social narrative. No one spoke of a controversy because, functionally, none existed anymore. The archive's role in this disappearance was passive but powerful. By maintaining documents without review, it allowed the institutional version to overwrite competing possibilities. The archive did not assert that the record was complete. It implied it through preservation. That implication was enough. Future researchers encountering the file would see a settled arrangement, not a live question. This period also illustrates how administrative forgetting serves as closure. Systems do not require explicit conclusions to move on. They require only the absence of prompts to reconsider. By 1924, the case no longer prompted anything. It existed in storage, not in discourse. The administrative act of leaving it untouched functioned as an endpoint. The disappearance was total in one crucial sense. There was no longer a place in the system where the question could naturally arise. Courts had acted, registries had deferred, archives had absorbed. Each institution had completed its role. Together, they produced a silence that no longer needed reinforcement. What remains from these years is a physical stillness. Boxes labeled with dates, folders containing papers that do not speak unless asked the right way, shelf marks that reflect classification decisions made decades earlier. The disappearance is not dramatic, it is orderly. This stage resolves the tension between unresolved harm and institutional stability. The harm has been completed, stability has been achieved, the system has moved on without ever articulating why. The case has not been solved. It has been concluded by time. The investigation now reaches a critical threshold. When silence extends long enough, it invites a different kind of scrutiny. Disappearance creates gaps that can no longer be explained by process alone. Over decades, numbers drift, dates misalign, and records begin to resist the story they are meant to tell. The next step is not to revisit what vanished, but to examine whether what remains can still be made to agree with itself. The transition point is a simple image, a storage box in the municipal archive, stamped with a transfer date from 1918, its contents intact, its folder tabs yellowed, and its classification unchanged, waiting not to be opened, but to be compared. In 1998, the case returned to the surface not because an institution chose to correct itself, but because a different kind of reader arrived with different incentives. The setting was Columbia University Libraries, where a research project on late 19th century urban records relied on cross-referencing tools that clerks of the 1890s never expected to be used that way. The action that reopened the file was concrete, a systematic index comparison across series that were supposed to mirror each other. The consequence was also concrete and immediately limiting. The inconsistency was recognized in an academic context, documented as a historical problem, and yet carried no legal force. The record could be described, but it could not be repaired. By the late 1990s, research culture had shifted. Scholars no longer approached archives as linear narratives. They approached them as systems with internal rules that could be tested by comparing one series against another. That method mattered here because the case had survived by being absorbed into structure. A missing entry in a public-facing index could be dismissed as relocation, backlog, or routine reclassification. But in 1998, the researcher did not follow the public path alone. They followed parallel paths and compared outcomes. A ledger sequence that looked plausible in isolation began to look unstable once placed beside its supposed counterpart. The inconsistency did not announce itself as scandal. It appeared as a mismatch, a reference in one series to an item that, according to the other series, should have generated a corresponding trace. The action was not interpretive, it was mechanical. Page numbers were checked. Date ranges were aligned. Call numbers were verified. In a matter of hours, the researcher could demonstrate something that the system's earlier design had discouraged, that the absence was not simply not found, it was structurally unusual. This is the first time the archive speaks again, not because a missing page is discovered, but because the system's own redundancy fails to reconcile. Well-designed record systems contain cross-checks. They assume that if one pathway is compromised, another will confirm continuity. In this case, the cross-check did the opposite. It revealed discontinuity that should not exist if the omission were merely clerical. The researcher did not need to allege misconduct. The structure itself produced the contradiction. The immediate consequence was academic reopening. Notes were taken. Photocopies were requested. Citations were drafted. In 1998, that process created something the case had lacked for nearly a century, a coherent written account of why the omission mattered. but the limits were just as clear. Academic recognition does not restore standing. It does not reopen estates. It does not unwind trust structures that had been consolidated in the early 20th century. The record could be questioned historically, but the outcomes it had produced remained legally settled. That limitation is not a failure of scholarship. It is the defining boundary between historical truth and legal effect. Inheritance law is built on finality. Property systems depend on stability. Even when a record is shown to be inconsistent, the modern system rarely invites retroactive correction unless there is a live claimant, a viable procedural vehicle, and a clear remedy that does not destabilize a broader chain. In this case, the chain was the point. The silence had produced a stable landscape, and stability is protected even when its origins are questionable. Still, the academic reopening changed something important. It changed who could see the case. Prior to 1998, the absence survived partly because it required insider navigation to locate. Once the inconsistency was documented in research notes and referenced within a library context, it became legible to outsiders. It did not become actionable, but it became describable. It could be taught, cited, and compared against other patterns. Of administrative omission, the researchers' work also made the earlier institutional logic more visible. When you reconstruct a gap across multiple indices, you begin to see how earlier choices shaped later access. A reclassification in 1899 no longer appears as neutral organization when it can be shown to have redirected discoverability. A probate denial in 1901 no longer appears as routine closure when the missing proof can be linked to earlier administrative non-action. In 1998, the archive did not confess. The archive was made to answer questions it had not been designed to answer. But the most sobering consequence of the academic reopening was the recognition of irreversibility. Scholarship can restore narrative coherence, but it cannot restore what law has extinguished. The claimant denied in 1901 could not be reinstated. The reputations preserved through silence would not be retroactively stained in court. The trusts consolidated in 1902 would not be unwound. What could be regained was understanding, not remedy. That is the moral restraint of this stage. The researcher's discovery does not transform the case into a crusade. It transforms it into evidence of method. It demonstrates that omission can be documented after the fact, even when it was designed to resist documentation. It also demonstrates the cost of delayed scrutiny. When institutions defer long enough, they shift the problem from correction to interpretation. By the time the truth is readable, its consequences have already matured beyond legal reach. In 1998, the work remained contained within academic channels. There was no court filing, no formal petition to reopen anything, no press cycle. The action was careful: compile the inconsistency, preserve copies, and place the finding within a broader study of urban administrative practice. The consequence was quiet. The case gained a second life as historical evidence while remaining inert in the legal world. This is where the investigation changes direction again. Until now, the story has shown how silence can generate outcomes and how time can lock them in. The reopening in 1998 proves that the system's own structure contains detectable strain. That strain becomes the basis for a more precise question going forward. If one inconsistency can be demonstrated through cross-referencing, what does that imply about the system that produced it? The next step is not to chase a remedy that cannot exist. It is to map the method as a system. That requires looking beyond the single case and examining whether the same institutional logic, omission, reclassification, non-decision, appears elsewhere. and whether the government's own frameworks ever acknowledge the risk of silence as policy. The physical image that closes this chapter is plain and modern. A reading room desk in 1998, a stack request slip stamped and returned, 2 index volumes opened side by side, and a pencil line drawn under a reference that does not resolve, because the corresponding entry where it should be is still not there. What the 1998 rediscovery exposes is not a single gap, but a governance pattern that had room to exist in 1900 precisely because no higher authority required it to be treated as dangerous. At the turn of the century, the architecture of American administration allowed local systems to govern by silence without formally admitting that silence was a tool. The named federal presence here matters for what it did not supply. In 1900, the U.S. Department of Justice did not issue meaningful guidance that treated municipal non-action, omission, delay, procedural deferral, as a distinct class of administrative conduct requiring oversight. The action is not symbolic. It is operational absence, no standardized federal expectation that local record-keeping offices must respond, clarify, or document reasons when they decline to act. The consequence was structural autonomy. Cities like New York retained wide discretion to manage conflict through quiet practices that left minimal trace and created maximal durability. This is the point where the case becomes a method. A failure implies deviation from a rule. A method implies alignment with incentives under permissive conditions. The events we have tracked, petition received and archived, court declining to direct correction, archival reclassification without public notice, probate denial for lack of proof, trust consolidation without challenge, form a coherent chain only if silence is treated as a governing option. And in 1900, silence was exactly that, an option preserved by the absence of external constraint. The American system at the time was not designed to police every internal practice of municipal offices. Federal authority was limited and targeted. The Justice Department's focus lay primarily in federal crimes and matters of national jurisdiction. Administrative fairness in local record-keeping was not yet conceptualized as a federal concern in the way it would later be under modern civil rights frameworks, due process litigation, and expansive administrative law doctrines. That limitation created a jurisdictional shadow. Local institutions could interpret their obligations narrowly and still appear fully compliant with the law as it was understood. Silence was not illegal, it was unclassified. This unclassified status is what made silence usable. When a practice is not named, it is hard to challenge. You can challenge a forged document. You can challenge a denial. You can appeal an order, but omission produces none of those hooks. In 1900, there was no general requirement that a municipal registry or archive provide a substantive written rationale for inaction in matters that shaped property rights. The law assumed that disputes would declare themselves through litigation, but this case demonstrates how disputes can be neutralized before they ever become litigable, simply by denying them procedural life. The method operates through a sequence of small moves, each defensible in isolation. A clerk holds a file pending additional information. A registry archives a petition without a formal response. A court declines to issue a directive in a matter framed as technical. An archive reclassifies indices to increase internal efficiency. A probate court denies a claim for insufficient proof. A trust consolidates assets once the field is clear. None of these steps requires an explicit conspiracy. They require only shared incentives, minimize exposure, preserve stability, avoid precedent, reduce administrative burden, protect the appearance of coherence. The key is that the method is cumulative. In 1900, the system did not need a single decisive moment of suppression. It needed a pathway in which each institution could plausibly claim it had simply followed routine. Silence is powerful because it distributes responsibility. When the outcome becomes visible, when someone loses rights, when assets consolidate, when reputations remain intact, no single office appears to have caused it. The method eliminates authorship. The absence of federal guidance amplified this dynamic by ensuring that local practices remained local facts rather than national issues. Without a standardized expectation that omissions must be logged, explained, or reviewable, municipal offices could treat silence as a neutral default. No action taken became an end state rather than a decision requiring justification. That status allowed omission to function like a verdict while avoiding the accountability structure that normally accompanies verdicts. This is where silence becomes a mechanism of power rather than a technical byproduct. Power is not only the ability to act, it is the ability to decide what counts as an event. In this system, action was recordable and therefore contestable. Inaction was often unrecorded and therefore durable. The method protected elite stability because it placed the burden of motion on the least resourced party. If you lacked capital, legal time, or institutional access, you could not force the system to speak. And if the system did not speak, you could not build the record required to challenge it. In 1900, this arrangement aligned with the social structure of the Gilded Age's aftermath. The city's visible order depended on the invisibility of certain disputes. Elite institutions benefited from continuity. Courts benefited from avoiding destabilizing precedents. Archives benefited from efficiency and internal coherence. Professional bodies benefited from limiting exposure. Federal institutions benefited, at least in the short term, from not expanding oversight into politically sensitive municipal territory. Each actor had a rational incentive to treat silence as acceptable. The consequence was a landscape in which omission could become policy without being written as policy, not in the sense of a directive instructing clerks to ignore certain people, but in the sense of a system that repeatedly rewarded non-intervention. Over time, that reward structure becomes indistinguishable from policy. It shapes behavior predictably. It produces consistent outcomes. It survives personnel changes. It persists even when the original context is forgotten. This is also why the 1998 rediscovery matters despite its lack of legal effect. It exposes the method's footprint. When you cross-reference indices and find a contradiction that should not exist, you are not merely finding an error. You are finding a system that has learned to contain questions rather than answer them. The archive speaks again not because it chooses to confess, but because its internal logic cannot perfectly erase the evidence of its own design. The risk of naming silence as a method is that it forces institutions to confront something they prefer to leave unclassified. If silence is recognized as an administrative act, it becomes reviewable. If it becomes reviewable, it threatens precedent. And precedent threatens the stability that silence was built to protect. That is why the method is rarely articulated. It is most effective when it looks like nothing. By 1900, the method was already mature enough to produce irreversible outcomes without overt conflict. It had turned an omission into a denial into a consolidation, and consolidation into historical normality. The system had not failed. It had performed as designed under permissive conditions. The final stage of this investigation must now do what institutions avoided: connect the method to the present. not by claiming the past can be repaired, but by identifying what remains unresolved, what still cannot be reconciled in the record, and what the endurance of this method implies for modern governance. The case is no longer a missing entry. It is a demonstration of how authority can operate through non-events. The image that closes this chapter is a quiet one and precise. A municipal archive box, labeled with a turn-of-the-century classification code, a cross-reference card from a later era tucked inside, and a modern researcher's note from 1998 clipped to the folder. 3 layers of time, aligned around the same absence, each one proving that silence was never emptiness, it was structure. In 2026, the most unsettling part of this case is not what can be proven, but what still refuses to be named. The paper survives, the ink survives, the sequence survives just enough to look respectable from a distance. And yet, when you set the old machinery beside the modern ideal of transparency, the silence does not vanish. It becomes legible as a design choice. This is why the comparison matters. When institutions today speak of access, accountability, and standards that outlive the people who enforce them, they do so in response to a long century of lessons learned the hard way. The National Archives and Records Administration exists within that contemporary promise, that preservation is not merely storage, but a public obligation, that records are not ornaments of authority, but restraints upon it. But a record can be preserved and still be arranged to resist you. A system can comply and still withhold. The Gilded Age understood this with a precision that rarely required a written instruction. A corridor can be open, yet led nowhere. A ledger can be intact, yet yield no answer. An index can be present, yet conceal the very continuity it claims to guard. That is the enduring legacy here. Not a forged document, not a dramatic edict, but the quiet triumph of an administrative non-event, an omission that produced consequences as final as any judgment. If there is a moral in these halls, it is not sentimental, it is institutional. What happened in these years was never permitted to become a scandal, because scandal requires noise. A charge, a denial, a hearing, a headline. Silence is safer. Silence does not demand a reply. Silence leaves no signature to prosecute, no line to cross-examine. It distributes responsibility across polished desks and locked cabinets until causation becomes a fog, and then it calls that fog routine. Once the field is cleared, once claims fail for lack of proof, once assets settle into structures designed to outlast memory, the silence no longer needs defenders. It becomes history's default setting. And yet the archive, even when quiet, is never truly dead. It is a building that remembers in its own cold way. Doors close, but they do not seal the air. Boxes are tied, but they do not erase the shape of what is missing. Somewhere in a catalogue, a cross-reference persists like a ghost of intent. Somewhere in a transfer stamp, a date remains indifferent to the lives it ended. And somewhere between the promise of modern transparency and the older habits of discretion, a question stays unresolved. How many outcomes were natural, and how many were engineered by refusal? This is why the case still matters. Not because we can restore what was lost, or summon a remedy from a century that has already passed judgment by fatigue. It matters because the method survives. Every era has its own vocabulary of restraint, its own polite phrases for postponement, for jurisdiction, for no action taken. The architecture changes, the standards improve, the rhetoric becomes noble, yet the temptation remains the same, to let time do what power prefers not to sign. So we leave this file where it belongs, inside the tension between record and Authority. We close the folder, not as an ending, but as a boundary. We listen to the soft scrape of paper returning to its sleeve, the weight of a box settling onto a shelf, the brief click of a lock that does not announce itself to the public. Leave your thoughts below. Every perspective helps illuminate what history tried to bury. If this story resonated with you, let us know. It tells the algorithm these forgotten halls are worth exploring again. And consider subscribing quietly, so that you're here when the next sealed door finally opens. And if you're willing to step deeper into the shadows, the next chamber awaits. Because some secrets do not survive through strength, but through etiquette, through the careful decision to leave no one responsible enough to confess. And in these halls, the most enduring mysteries are the ones that still sound, even now, like nothing ever happened.